Imagine this scenario. You are living your absolute best life in New York City. You finally got your apartment set up, and you decide it's time for the centerpiece. The sofa.
Ah, the all-important sofa decision.
It's huge. And you go online, and you find this incredible boutique furniture company. They have this mid-century modern aesthetic that is just perfect. But they are based entirely in California.
Okay.
No stores in New York, no warehouse in New Jersey.
Or you see where this is going.
So you pull out the credit card, you drop a serious amount of money, and you order a custom sofa. Fast forward 6 weeks, it arrives. But it is a disaster.
Oh, no.
It's broken, the leg is snapped off, the fabric is the wrong color, it's neon green instead of beige.
Yeah.
And just to add some nightmare fuel to the fire, it has bed bugs.
That is absolutely horrifying. A true consumer worst-case scenario.
It really is. And naturally, you are furious.
Right.
You want your money back, you want damages for the exterminator you now have to hire, and you want compensation for your emotional distress. You want to sue them. And obviously, you want to sue them in a court down the street from your apartment in New York. You don't want to fly to California to fight this. But here's the question that stops everything cold. Can you? Can you actually force that California company to show up in a New York courtroom? Or does the judge look at you and say, sorry, I literally do not have the power to make them come here?
It sounds like a simple logistical question, just pick a court and go. But what you have described is actually the fundamental question that keeps civil procedure professors up at night.
Right.
And looking at the stack of research we have today, from law school essentials to the Themis Bar review notes, the answer is definitely not as obvious as people think. Just because a court exists doesn't mean it can preside over everyone.
Exactly. And that is what we are unpacking today. We are taking these dense legal concepts, which, let's be honest, usually bore law students to tears, and turning them into a survival guide. Our mission is to understand how the law decides who controls you.
We are talking about impersonam jurisdiction.
Impersonam. It sounds very Roman Empire.
It is Latin for against the person. Put simply, it is the legal power a court possesses over an individual person or a distinct entity, like a corporation. And before we get into the weeds of the how, we have to establish the why. Why does this matter?
Right, because I think the common assumption is that if I win a lawsuit, I win. If I get a piece of paper saying you owe me $5,000,
All right.
Why does it matter where I got it? Why can't I just get a judgment against the sofa guys in New York, even if they ignore me?
You could try. I mean, you could stand in an empty courtroom and get a judge to sign a piece of paper. But without an impersonam jurisdiction, that judgment is essentially a piece of paper with no teeth.
No teeth.
None. But if a court has proper jurisdiction and issues a judgment against you, they can enforce it. They can seize your assets, your bank accounts, your car, your house to satisfy that debt. That judgment is entitled to full faith and credit in every other state.
Full faith and credit.
Yeah.
So if I win in a valid court in New York, California has to respect it.
Exactly. They have to help you collect. But, and this is the big but, if the New York court lacked impersonam jurisdiction over the defendant, the judgment is void.
Void.
Meaningless.
Legally meaningless. You can't enforce it anywhere. The California courts will look at it and, throw it in the trash.
So the stakes are basically everything you own. If the court has jurisdiction, they can take your stuff. If they don't, you are untouchable.
Precisely. It is the gatekeeper of judicial power.
Okay, so our mission today is to map out this power. Looking at the outline, we've got a clear roadmap. We are going to look at the easy ways courts get this power, the old school rules.
Right, the traditional ways.
Then we'll get into the hard ways involving the long-arm statutes and the Constitution. And finally, we have to talk about how they actually tell you that you're being sued, which is service of process.
It is a roadmap of judicial reach.
Let's start with the basics, the easy ways. I was reading through the case summaries and the notes, and there's this concept of voluntary presence. I call it the tag you're it rule. That is a very accurate, albeit playground-style way to describe it. It's a perfect analogy.
So let's go back to our California furniture guy. Let's say he refuses to answer my emails. He refuses to come to New York to deal with the bedbug sofa.
Okay.
But by total coincidence, he has a layover at JFK Airport in New York on his way to London. He steps off the plane to stretch his legs. If I run to the airport, find him at the gate eating a bagel, and hand him the lawsuit papers, do I have?
You absolutely do. This is the rule from a famous Supreme Court case, Burnham v. Superior Court. If a defendant is voluntarily present in the forum state, even for a fleeting moment, and they are served with process while physically there, the state generally has jurisdiction.
Even if he has no business in New York? Even if he's just there for 2 hours and has never set foot in the city before, he's not even leaving the airport.
Even then, his physical presence in the state, combined with the official notice, the service locks him in.
Wow.
The logic, which Justice Scalia leaned into heavily in that decision, is based on tradition and physical sovereignty. It goes back hundreds of years.
What's the thinking there?
The thinking is, if you are standing on New York soil, you are protected by New York police, you are using New York infrastructure, you are breathing New York air.
Right.
In exchange for that temporary protection, you are subject to the power of New York courts. It's a sort of implied bargain.
That feels incredibly aggressive, though. It's a total gotcha moment.
It essentially is, and legal scholars have debated the fairness of this for decades. It seems archaic, especially in a modern world. But the rule stands. However, there are caveats. We have to be fair.
Okay, what are they?
You mentioned he was there voluntarily. That's the key.
Right. What if he wasn't? What if I tricked him into coming?
If you, the plaintiff, lured him into the state under false pretenses, say, you told him he won a free trip to a gala, or you told him his mother was sick in a New York hospital just to get him to fly there so you could serve him papers, that is fraud.
That's kidnapping by trickery, essentially.
Exactly. The court generally won't respect that service. You cannot use fraud to create jurisdiction. The court will see right through that.
Okay, so I can't trick him. What if he is there for a different legal reason?
That is the other major exception. Judicial immunity. Let's say our sofa guy witnessed a completely unrelated bank robbery in New York years ago. He is subpoenaed to come testify in that criminal trial.
Great.
If he flies in specifically to attend that court proceeding, he is generally immune from being served for a new lawsuit like your sofa case while he is there.
Why give him a free pass?
It's public policy. I mean, think about it. We want to encourage people to participate in the legal system. If witnesses knew that stepping into a courthouse to help with one case would make them vulnerable to being sued in 5 other cases.
Nobody would ever show up.
Nobody would ever show up to testify. The system would grind to a halt. So we give them this temporary shield.
That makes sense.
Okay?
So that's presence. Tag, you're it. What about the home court advantage?
That is the concept of domicile. A state always has power over people who are domiciled there. It's the most solid basis for jurisdiction.
I want to drill down on domicile, because I feel like people confuse this with residence. Is it just where I'm sleeping tonight?
No, it is much deeper than that. You can have many residences. A summer home in the Hamptons, a rental apartment in Miami, a hotel room in Paris. You can only have one domicile.
Just one, like a soulmate.
In a legal sense, yes. Domicile requires 2 distinct elements: physical presence in the state, plus the intent to make that state your permanent home.
Intent seems like a slippery thing to prove in court. How do they know it's in my head?
They look at your actions. It's all about objective factors.
Okay.
Where are you registered to vote? Where's your driver's license from? Where do you pay income tax?
Oh.
Where do you keep your most prized possessions? Where do you work? Where does your dog live? The court looks at the whole picture to find the center of gravity of your life.
So let's test this. If I am domiciled in New York, that's my home, all my stuff is there, but I go on a 6-month expedition to Antarctica to study penguins.
You are still domiciled in New York?
Even though I'm physically in Antarctica for half a year?
Yes, because you have the intent to return. You haven't decided to become a citizen of Antarctica, which isn't possible anyway, but you get the point. New York courts can still sue you and issue judgments against you while you are freezing in Antarctica, provided they can find a way to notify you.
So you can't escape jurisdiction just by leaving your home state temporarily?
You cannot. Your legal home follows you around like a shadow.
That seems fair. If you reap the benefits of being a New Yorker, you pay the price of being suable in New York. Now, the third easy way is consent. You can just agree to be sued.
People do it all the time, often without realizing it.
Is this buried in the terms and conditions that nobody reads?
Often, yes. This is express consent. You might sign a contract that has a forum selection clause. It usually says something like, I agree that any disputes arising from this contract will be litigated exclusively in the courts of Texas.
And courts uphold that, even if I didn't read the fine print.
Generally, yes. The Supreme Court has been very supporting of these clauses because they provide certainty for businesses. If a company does business in 50 states, they don't want to be sued in 50 different legal systems. They want to centralize it.
So there has to be a pretty high bar to get out of one of those clauses.
A very high bar, unless it is deemed a contract of adhesion, meaning it is so fundamentally unfair and forced upon you by a monopoly power that it violates basic equity, you are bound by it.
What about implied consent?
That happens frequently with businesses. For example, many states require businesses to appoint a registered agent in the state to accept legal papers as a condition of doing business there. By appointing that agent, the business is consenting to the court's power.
Now, there is a scenario in the notes that I found really tricky. It's what I call the trap. Let's say I get sued in a state where I don't live, say, North Dakota. I think this is bogus. They have no power over me. I've never even seen snow.
Right.
So I get on a plane. I fly to that court in North Dakota, and I march in to tell the judge, you can't sue me. I have no contacts here.
You have to be very, very careful here. You have likely just walked into a massive trap. This is the danger of voluntary appearance.
How is it a trap? I'm there to complain about the jurisdiction. That's my whole point for being there.
The rules are very strict, specifically Federal Rule 12b. If you show up and start arguing the merits of the case, if you say, I didn't break the sofa, or it wasn't my fault, or the contract is void, you have voluntarily appeared.
Oh, wow.
You have waived your objection to jurisdiction.
So by trying to defend myself on the facts, I accidentally gave them the power to judge me.
Exactly. You implicitly told the court, I am here to fight this case, which grants them the power to decide it. It's a huge pitfall for people who represent themselves.
So what is the right move?
If you want to challenge jurisdiction, you must do it in your very first response to the court. You have to file a motion to dismiss for lack of personal jurisdiction before or simultaneously with your answer regarding the facts.
So you have to raise the jurisdiction issue first, above all else.
First and foremost, if you wait or if you argue the facts first, the court treats it as if you have consented to being there.
Wow. Okay, note to self. Read Rule 12b before shouting at a judge.
Always good advice. Never shout at a judge, generally speaking.
So those are the easy ways. You're there physically, you live there, or you agree to it. But let's go back to our California sofa guy. He's not in New York. He doesn't live in New York. He didn't sign a contract agreeing to New York courts. And he's smart enough not to fly to JFK and get tagged.
Okay.
Can New York still reach him?
Now we enter the realm of the hard way. This is where modern civil procedure really lives. We are talking about long-arm statutes and constitutional due process.
The long arm of the law. It's not just a cliche from a cop movie.
No, it is a literal statutory mechanism. If a defendant is outside the state, the court needs two things to grab them. Think of it as a two-step analysis.
Okay, what's step one?
First, the state needs a long-arm statute that says, we allow our courts to reach out and take jurisdiction over non-residents who do X, Y, or Z.
X, Y, or Z being things like causing a car accident or breaking a contract.
Exactly. Some states, like Illinois or New York, might have specific lists. Committing a tort within the state, owning property in the state, transacting business in the state. If your conduct doesn't fit on the list, the state court can't grab you, period. End of story.
But other states are more aggressive.
Yes. States like California have what we call a maxed out statute. Their law essentially says, we take jurisdiction to the full extent allowed by the U.S. Constitution.
So California is saying, if the Constitution lets us, we're doing it.
Correct. So in those states, the analysis collapses into just one question. Is it constitutional?
And that leads us to the second hurdle. Just because the state wants to grab you doesn't mean they can, right?
Correct. The state law is the first hurdle. The second and much higher hurdle is the Due Process Clause of the 14th Amendment.
This is to prevent a court in Alaska from grabbing me just because I sneezed.
It is to prevent unfairness and overreach. The seminal case here is International Shecombe v. Washington from 1945. Before this case, jurisdiction was all about physical power. Are you in the state or not? It was very rigid. International Shoe changed the paradigm to fairness.
What is the rule from International Shoe?
It gave us the golden rule of personal jurisdiction. For a court to exercise power over a non-resident, that defendant must have certain minimum contacts with the forum state, such that the lawsuit does not offend traditional notions of fair play and substantial justice.
Traditional notions of fair play, that sounds remarkably vague for the law. Usually the law is, do not cross the double yellow line. This sounds like a vibe.
It is intentionally flexible. I mean, it's meant to adapt to a changing world. But over the years, the Supreme Court has broken minimum contacts down into a rigorous test. The most important factor they look for is purposeful availment.
Unpack that for us. Purposeful availment. It sounds like a corporate buzzword.
It means the defendant must have intended to engage with the state. They must have purposefully availed themselves of the privilege of conducting activities within the forum state, invoking the benefits and protections of its laws. It cannot be random, distinct, or accidental.
So if I drive to New York to sell my wares, I am availing myself of the New York market. I am using the roads, I am relying on the police, I am taking money from New Yorkers.
Yes, you're making a conscious choice to benefit from that state. And because you are making money there and using their infrastructure, it is foreseeable that you could be sued there.
Foreseeability. That's the second part.
Right. Under the worldwide Volkswagen case, the question isn't just, is it possible the product could get there, but should the defendant reasonably anticipate being hailed into court in that state?
Worldwide Volkswagen is a classic. Can you remind the listeners of the facts there? Because it really highlights the limit of this power.
Sure. So the Robinsons bought an Audi in New York. They lived in New York, but they were moving to Arizona. While driving through Oklahoma, they got into a terrible accident. They wanted to sue the car distributor in Oklahoma because the accident happened there. But the distributor only sold cars in New York, New Jersey, and Connecticut. They had no ads in Oklahoma, no agents, no business there.
So the only reason the car was in Oklahoma was that the customer drove it there.
That's it. It was what the court called the unilateral action of the consumer.
And the court said Oklahoma couldn't sue the distributor.
Yeah. Correct. The Supreme Court said it wasn't enough that it was foreseeable a car would drive to Oklahoma. Cars drive everywhere. What mattered was that the distributor didn't target Oklahoma. They didn't avail themselves of the Oklahoma market.
That's a crucial distinction. It protects local businesses from being sued across the continent just because a customer moved. If I run a bakery in Brooklyn and you buy a bagel and fly to London, I shouldn't be sued in London.
Exactly. That would be fundamentally unfair.
But let's look at a trickier scenario. The stream of commerce. This feels like where the rubber meets the road for manufacturers.
This is one of the most debated areas in law schools today. The Supreme Court itself can't seem to agree on it.
Okay, let's say Company A makes a small metal valve in Ohio. They sell it to Company B in Pennsylvania, who puts it into a giant machine. Company B sells that machine to a construction firm in Florida. The valve explodes in Florida, injuring a worker.
A classic fact pattern.
Can the Florida court sue the Ohio valve maker?
This is the Asahi problem. The valve maker put the product into this stream of commerce and it flowed to Florida. But did they purposefully target Florida, or were they just floating down the river?
They knew it could end up there, right? I mean, they aren't naive. They know they're part of a national supply chain.
Mere knowledge might not be enough. The Supreme Court is actually famously split on this. In the Asahi case, and later in McIntyre v. Nicastro, there were two main viewpoints competing.
Break them down. What's view number one?
One group of justices, broadly speaking, often led by Justice Brennan, argued that if you put a product into the stream of commerce and you know it is being sold in a state, that is enough. You are benefiting from the national market, you should answer to the national courts.
That feels like the fairness argument. You made the money, take the heat.
It's a very broad view of jurisdiction, but the other group, led famously by Justice O'Connor in Asahi, argued for a stricter standard. She said you need something more than just placing it in the stream.
Something more.
You need an additional act directed at the specific state. Did you advertise in Florida? Did you design the product specifically for the Florida climate? Did you have a customer service hotline for Florida residents?
So just floating down the river of commerce isn't enough for the strict view? You have to paddle toward the shore.
That is a brilliant analogy. Yes. Without that paddle, that purposeful direction, many courts will say Florida has no power over the Ohio valve maker. This protects upstream component manufacturers from being sued in jurisdictions they never intended to enter.
And the Supreme Court has never definitively picked a side.
They have not, which means for lawyers, it's a huge area of uncertainty. It depends on which court you're in and which view they tend to follow.
This leads us to a distinction I saw in the notes that seems huge for corporations. General versus specific jurisdiction.
It is massive, and the Supreme Court has tightened this up significantly in recent years, particularly in the Daimler case involving Mercedes-Benz.
Okay, help us separate these. Specific jurisdiction is what we have been discussing, right?
Yes. Specific jurisdiction means the lawsuit arises out of the defendant's specific contact with the state. You crash your car in Nevada. Nevada has specific jurisdiction over you for that crash.
But only for that crash.
Only for that crash. They can't sue you for your unpaid taxes in Vermont or a contract dispute in Maine.
It's a spotlight. It focuses on the specific event.
Exactly. Now, general jurisdiction is a floodlight.
A floodlight.
General jurisdiction means the court has total power over you. They can sue you for anything. A crash in France, a contract in Brazil, a slip and fall in Tokyo, because you are essentially at home in that state.
At home. For a person, that's domicile.
Mm.
What is it for a big corporation like General Motors or Amazon?
For a corporation, at home is incredibly narrow now. After the Daimler and Goodyear cases, it essentially means only two places.
Only two.
One, the state where they are incorporated, and two, the state where they have their principal place of business, usually their headquarters.
That's it. Only two places. But Amazon does business in every single state. They have warehouses everywhere. Can I sue Amazon in Texas for something they did in Germany?
No, not under a general jurisdiction theory. It doesn't matter for general jurisdiction. In Daimler, the court said you can't just sue a company anywhere they do substantial business.
So explain that case.
In Daimler, the case was about human rights abuses in Argentina, allegedly committed by a subsidiary of Daimler, which is a German company. The plaintiffs tried to sue in California because Mercedes-Benz USA sold a lot of cars there.
Okay.
The court said no. If Daimler, Mercedes, sells cars in California, you can sue them in California for a car that crashes in California. That's specific jurisdiction. But you cannot sue them in California for a crash that happened in Poland, or in this case, abuses in Argentina. They aren't at home in California.
That drastically limits where you can sue big companies for global issues. It prevents forum shopping, where plaintiffs try to find the state with the friendliest juries.
It does. It forces plaintiffs to go to the company's HQ or place of incorporation for those broad, unrelated claims. It creates predictability for the corporation.
Let's fast forward to the 21st century, the internet. If I have a website, am I everywhere? Because technically anyone in any state can see my site.
If the rule was having a website creates jurisdiction, every small business owner with a basic Squarespace page would be subject to every court in the world.
That would be chaos.
It would kill e-commerce. So courts use a sliding scale, famously from a case called Zippo.
Zippo, like the lighters.
The very same. The Zippo test creates three categories. At one end, you have passive websites. These just post information. You can read it, but you can't interact. These do not create jurisdiction.
Okay, like a brochure website. And the other end.
The integral, or highly interactive end, think Amazon. You browse, you buy, you enter credit card info, they ship to you. If you are doing that level of business with a state, you are definitely subject to jurisdiction there. You are virtually opening a store in their living room.
In the middle, the gray area.
The interactive middle ground. This is where users can exchange information with the host computer. Maybe you can sign up for a newsletter, post a comment, or have a user profile. Courts struggle here.
What do they look for?
They have to look at the level of commercial activity. Is it enough to say you are targeting the state?
It feels like almost everything is in the middle ground now. Social media, apps, platforms.
It is becoming harder to distinguish. But the key is usually the commercial nature. Are you trying to make money from that specific location? If you run a blog that just happens to be read in Texas, probably no jurisdiction. If you run a subscription service that targets Texas users with Texas-specific content, probably yes.
Speaking of the internet, what about online defamation? If I write a nasty blog post in Florida about someone in California, I never left Florida. Can California drag me there?
This is the Calder effects test, named after Calder v. Jones. In that case, a writer in Florida wrote a libelous article for the National Enquirer about an actress in California.
Right.
The Supreme Court said California did have jurisdiction.
Why? The writer stayed in Florida?
Because the writer knew the brunt of the farm would be felt in California. That's where her career was, her reputation. They aimed their conduct at the state. Even though they physically stayed in Florida, their intent was to blow things up in California.
That makes sense. You can't throw a rock across the border and say, I didn't touch you. The impact is what matters.
Exactly. Intentional torts allow for this broader reach because of that aiming element.
What about contracts? If I sign a contract with a guy in Texas, does Texas own me now?
Not automatically. The Supreme Court in Burger King v. Redzovich, yes, the burger chain, said that a contract alone isn't enough. You have to look at the relationship.
What specifically did they look at in Burger King?
They looked at who pursued whom. Redzovich, the franchisee in Michigan, reached out to Burger King HQ in Florida. He entered a 20-year relationship. He agreed to send money to Florida every month. He agreed to follow Florida's regulations.
So it wasn't a one-off sale, it was a marriage.
A 20-year corporate marriage. The court said that by reaching out and establishing that long-term relationship, he purposely availed himself of Florida. Also, the contract had a choice of law provision selecting Florida law. That's a huge factor.
It sounds like Burger King is a warning to franchisees. You are tying yourself to the HQ state.
Very much so. It emphasizes that you cannot ignore the location of the party you are doing deep business with.
All right, we've covered state rules extensively, but what about federal court? I always assumed federal court was this all-powerful entity that covers the whole country. If I sue in federal court, can't I drag anyone from anywhere in?
That is a very common misconception. You would think a U.S. district court implies power over the entire U.S. But under Federal Rule 4K, 1A, a federal court generally has to pretend it is a state court.
What does that mean?
It means if you file a lawsuit in the federal court for the Southern District of New York, that court usually only has personal jurisdiction if a New York state court would have jurisdiction. It is tethered to the state's long-arm statute.
That seems inefficient. Why handicap the feds?
It respects state sovereignty and prevents forum shopping between state and federal courts in the same location. But there are exceptions. There's the famous 100-mile bulge rule.
I love that name. The 100-mile bulge. It sounds like a dieting problem.
It is quirky. Under Rule 4K, 1B, if you were joining a necessary third party to a lawsuit, say, the guy who actually caused the accident is a third-party defendant, the federal court can grab them if they are within 100 miles of the courthouse, even if they are across state lines, and the state court couldn't reach them.
So the federal court has a slightly longer arm.
Just a little bulge of an arm. And then there is the federal safety net, Rule 4K2. This is for when a defendant, usually a foreign national, violates federal law but doesn't have enough contacts with any single state to be sued there.
So they are slippery. They did bad things in the U.S., but not enough in New York, not enough in Texas.
Right. If they have enough contacts with the United States as a whole, the federal court can take jurisdiction, even if no single state court could. It prevents a foreign defendant from slipping through the cracks of the state system.
Clever. Now, I want to shift gears to something that sounds super archaic, but is still in the books. Jurisdiction over things.
In rem jurisdiction.
Against the thing.
Historically, this was a distinct concept. In rem is when the lawsuit is about ownership of property itself. Who owns this land? Who owns this boat? The court has power over the property because the property is physically in the state.
That makes sense. The land can't move. If we are fighting over a farm in Nebraska, the Nebraska court should decide. But what is quasi-in rem?
Quasi-in rem, or attachment jurisdiction, was a loophole. It used to be that if you owned anything in a state, a bank account, a vacation home, even a watch you left in a hotel, a plaintiff could seize that property to start a lawsuit against you for something totally unrelated.
So if I left my watch in a hotel in Oregon, someone could seize the watch and sue me in Oregon for a car crash that happened in Maine.
Historically, yes. Under the old Pennoy v. Neff rules, that was allowed. The presence of the property gave the court power over you, up to the value of that property.
That sounds insane.
It was. And everything changed in 1977 with a case called Schaffer v. Heitner.
What did Schaffer do?
It said, stop the madness. The Supreme Court ruled that all assertions of jurisdiction, even over property, must satisfy the international shoe test. You need minimum contacts.
So I can't just use the watch as bait.
No. Unless the lawsuit is about the watch, the mere presence of your property in Oregon isn't enough to give Oregon power over you personally. The property must be related to the claim, or you must have other minimum contacts. Schaffer essentially killed the old-school quasi-in rem loophole.
R.I.P. to the loophole. Okay, so we have established that the court has the power, the judge is ready, but the defendant is sitting at home totally unaware. We need to talk about you've been served.
Service of process. This is the implementation of notice.
Is this purely a technical rule? Like, do I just need to fill out the form correctly?
No, it is a constitutional requirement. Notice is the twin sibling of jurisdiction. In Mullane v. Central Hanover Bank, the court said notice must be reasonably calculated under all the circumstances to apprise interested parties of the action.
So sticking a Post-it note on a tree in the park is not enough?
Definitely not. If you know their address, you generally have to mail it or deliver it. If you don't know where they are, you have to try really hard to find them. Publication like putting an ad in a newspaper is a last resort.
Only is last resort.
You can only use it if you truly cannot find them after a diligent search. You have to prove to the court you tried everything else.
Let's talk about the mechanics. Rule 4. Who can serve the papers? Can I, the plaintiff, hand them to the guy I'm suing?
No, it must be a non-party who is at least 18 years old. You cannot serve your own papers. Too much conflict of interest, too much potential for he said, she said.
And there is a ticking clock.
Yes, usually 90 days after filing the complaint. If you don't serve them in 90 days, the court can dismiss the case without prejudice.
How do you physically give it to them? Do you have to touch them with the papers?
Personal service, handing it to them directly, is the gold standard. But you can also leave it at their usual place of abode with someone of suitable age and discretion who lives there.
So I can leave it with their wife. Can I leave it with their 5-year-old kid?
No, a 5-year-old does not have suitable discretion. They might eat the papers, make paper airplanes, or just forget to give them to dad. The court wants to be sure the defendant actually gets the memo.
Good point. Now, what about waiver of service? This sounds like a deal you make.
It is a trade-off designed to save money. Process servers are expensive. It costs money to hire a guy to stake out someone's house. So the plaintiff can mail the defendant the complaint and say, hey, please waive formal service.
Why would a defendant say yes? Sure, I'll make it easier for you to sue me.
It sounds counterintuitive, but there is a carrot and a stick. The carrot is time. If you waive formal service, you get 60 days to answer the complaint instead of the usual 21 days.
A lot more time.
It is valuable time to find a lawyer, build a defense, and strategize.
And the stick.
If you refuse to waive without a good reason, the court will force you to pay the bill for the process server. Why make you pay $100 or $500 just to have a guy hand you papers you could have accepted by mail?
So it's usually smart to waive.
Usually. And here's the most important part that lawyers always emphasize. Waiving service does not waive your objection to jurisdiction.
Wait, really? I thought we said earlier if you participate, you get trapped.
That was if you argue the facts. But waiving the method of delivery is different. You can sign the waiver, get your 60 days, and then in your very first motion say, I waived service, but I still argue this court has no power over me. It is a safe move.
That is a crucial distinction. Don't confuse waiving the paperwork with waiving the power.
Exactly.
Okay, we have covered a massive amount of ground today. From the tag rule at the airport, to the stream of commerce vows, to the digital sliding scale of the internet.
If we zoom out, what we are really seeing is a balancing act.
Unpack that for us.
It is the balance between a state's right to protect its own citizens, like the New Yorker with the bedbug sofa, and the defendant's right not to be dragged halfway across the continent to a hostile court where they have never set foot.
It's protection versus fairness.
Exactly. The law is trying to evolve as our world gets smaller. International Shoe was about salesmen carrying samples. Worldwide Volkswagen was about cars on the highway. Zippo was about the early internet. The tools change, but the question remains, is it fair?
And that leads me to my final thought for the listener. We talked about domicile, where you physically live and intend to stay. And we talked about being at home.
Yes.
But we are moving into a world of decentralized assets. Crypto. DAOs, decentralized autonomous organizations, remote work where people are digital nomads, living in Airbnbs for a month at a time, never staying anywhere long enough to establish domicile.
It raises a fascinating problem.
Right. If you exist entirely in the digital cloud, if your assets are on a blockchain that isn't in any specific server and your body is constantly moving, can any court on earth claim you? Or are we creating a class of people who are essentially beyond the reach of Impersonam jurisdiction entirely?
It challenges the very geographically based foundation of our legal system. If you are everywhere, are you nowhere? The courts haven't fully solved that one yet.
Something to think about next time you buy a sofa or an NFT online.
Indeed.
That's it for this deep dive into the long arm of the law. Hopefully, you now know exactly what to do and what not to do if a process server shows up at your door.
Read Rule 12b.
Always read Rule 12b. Thanks for listening, everyone.